cost outline, which is right here, you're going to see this being used way more than a bill of costs.
Right.
So again, you're going to put in above the cost outline.
Yep.
Up here, you're going to put in your title of proceedings.
Right.
And then here, the party. So if you're the plaintiff, you're the defendant, the plaintiff, John Doe, provides the following outline of the submissions. And you keep all of this wording. That's all supposed to go in there. These areas we keep as well. But the numbers that we put into the columns over here is something that I always do that at the end, because I add up all the amounts and then I put the amounts in here. So even though it kind of comes first, I leave that for the end to do.
Right.
And this is really simple, because as long as you copy the form, you're going to be in a great position. So keep this line.
Right. Okay.
And now in the space provided, you would answer the bullet points.
Okay.
So for example, if you have a motion for answers to undertakings and a party has failed to provide the answers, then you can say like why you need $2,000 for bringing the motion. So you might say the amount claimed in the recovered in the proceeding, you might say the amount claimed is X dollars. There's no amount recovered yet in the proceeding. So you can address that as like not being applicable at this time. But if it's $1 million lawsuit, then of course you're going to want full productions. And then the complexity of the proceeding, you can talk about like how complex the action is, but you can also talk about how complex the motion was. Was it an easy motion? Was it a hard motion? The importance of the issues. So you have to link what the motion is about to the broader issues in the case. The conduct of any party that tended to shorten or lengthen the duration of the proceeding. So maybe you sent like 5 letters to the other side before you brought this motion. It was a last resort and they ignored it. They never responded. That's something that lengthened the proceeding and required you to bring the motion. Whether this step in the proceeding was improper, this part might be more for the responding party to address, or maybe there's nothing in this motion that really addresses that point. You can leave it. You can say like not applicable. Right. Like if the other party hasn't done anything improper, then don't accuse them. Right. Just because there's a section in there for being improper.
Right. Good.
And then and I would go through the rest of the questions the same way. Yeah. And then here, the experience of the parties' lawyers. Again, you would put the name of the lawyer and any law clerk or paralegal that worked on the file and their year of call. So if you're called in 2013, called in 1994, that's something the court looks at, because generally, the longer you've been practicing, the more you are charging as a lawyer.
Right.
So here, again, you're going to copy this chart. Right. Exactly. You're not going to change it at all. Right. So fee items. You can put in this section here, for example, maybe it's drafting the affidavit, drafting the notice of motion, drafting the cost outline. Maybe you want to put that in there. You can have some leeway in how you want to divide the work that was done. And normally there's some information for the correspondence that was exchanged prior to the motion as well. And then you're going to identify, like if let's say I drafted the notice of motion with a law clerk and I put 0.5 of an hour and the law clerk put 1 hour, and you can identify that I did 0.5 and she did 1 hour. And then here you would put the hours. So Heather Douglas and then another law clerk put the hours. and partial indemnity rate. Then I would put the amount that was. So if I'm billing at $100 an hour,
Mm-hmm.
partial indemnity is usually calculated around 50 to 75%. So a lot of people just choose 60%, and I can multiply it by 60% and then put $60. And then in this column, put my actual rate of $100. But usually, the court will look at it and award partial indemnity rate. You'll rarely see an actual rate, like your full rate, being awarded at a motion.
But how do you does the court ever ask you to justify your 60% or 75%? Like, isn't it better to just put in 75% then?
I think most, like a lot of people might put in 60, 66%.
Right.
The court will look at it and they have the discretion to decide whether it's an acceptable amount. It's somewhere in that range. It gets kind of confusing because the way it's defined under the rules of civil procedure is in reference to the tariffs. But the tariffs are no longer being used as mandates, like as it has to be followed exactly. The court has the discretion to award an amount.
Oh, I see. So I finally understand how this works. So basically, you kind of put in what you think is a reasonable amount. Like, okay, to me, I would say 60% is reasonable. I put that in there. And then it's up to the judge. It's up to the judge whether they award that to you. They can always change it. Yeah, they can always say, no, 60% is not fair in this case. I award 50%. Like, ultimately, it's up to the judge.
Yeah, the judge can even say at the end of this, even though you won, I'm going to award costs to the losing party.
Right, that's true.
That's exceptionally rare.
Right.
Don't count on that.
Right.
It's very, very rare, but it does happen, and it ultimately goes to the court's inherent jurisdiction to decide whether a party is entitled to costs and to what amount.
Very
and the cost outline just provides the court with the insight into how much time, how much money really was incurred for this step.
So just a quick question, a couple quick questions before we wrap up this really useful video. I don't remember you talking about disbursements in this form. Were there, do you include disbursements somewhere in this form?
Yeah, a lot of times.
I probably missed it.
Oh no, we haven't gotten there yet. Sometimes people will put the disbursements onto the last page, like, and when it says any other matters relevant to the question of cost, they might list the disbursements here. Or they can say, like, see Schedule A and attach as a schedule the disbursements. And the disbursements will likely be like the filing fee, paying for photocopies if you're filing it in paper, paying the process server to serve and file it. So you're going to see those kinds of disbursements being incurred. And then the last thing is the lawyer would sign the cost outline and date it. And the cost outline is normally exchanged between the parties at the motion, sometimes before, but usually at the motion, and maybe even after the motion.
Right.
If it's a complicated motion, then the court will reserve their decision and they'll invite submissions for costs afterwards. And they'll look at your cost outline, but they'll also request up to 3 pages of submissions as to why you are entitled to your costs.
So when you say the word submissions, just in case people are not aware of what that means, so basically that's just your legal argument that you're arguing for your position in costs. Is that correct?
Yeah, it is. Sometimes a court wants to just look at a cost outline, but if it's a more complex motion, they will oftentimes welcome short written submissions, like a short written argument as to why you're entitled to the amount that you're seeking.
Are the disbursements, is there a partial indemnity, substantial indemnity application to disbursements, or would they be just like fully compensated?
Usually the disbursements are
100%.
oftentimes are fully compensated, but the legal fees that are incurred are rarely fully compensated, and only in exceptional cases will a court award you the full amount, because that's considered to be very punitive to make someone pay the full amount of the legal fees.
Okay, so this is really the last question. Now, I know that because this form at the very bottom, it talks about lawyer certificate and things like that, your hours. Now, for a self-represented person, I guess, did they just skip that part where it says lawyer certificate? I mean, for a self-represented person, do they still use this form, or do they use some other form?
The self-represented person should still fill out a cost outline.
Yeah.
The court can still award fees to a self-represented litigant.
Right.
They're likely not to award you the same way that they would compensate a lawyer.
Yeah.
But there is a way for the courts to consider the amount of time and effort that a self-rep has put into a case.
So now, do you still have to sign, like just like the way here, the lawyer certificate? Would you just cross out the word lawyer and say self-represented person? Or?
If I was self-represented, and I don't know if this is correct, I would sign it. Yeah. But I would change it to, like, I would take out the word lawyer certificate. Yeah. But I would still sign it to show like that this is what I'm putting forward, something that I think is true. Right.
Wow, right. So it's really important that if you're a self-represented person, you should keep track of the number of hours that you're spending. Like if you are working on your arguments or your submissions, you should make sure that you keep track of all that. Okay, so is there anything else that you wanted to share with us today on these forms?
I think that's about everything on the forms. Okay. And if you're self-represented, make sure you point out to the court the amount of time you did put into it, but also perhaps like the amount of money you might have lost in income by working on this case. So it gives them some context as to like what amount to award you if they are going to award you anything.
That is a really good suggestion, because obviously if you're asking for something, you should always have some form of justification. You don't just pull a number out of the air and say, I want.
Yeah, don't say like I'm $500 an hour because the other lawyer's $500 an hour. Right. The court's going to want to know where you got that number from.
Excellent. Well, thank you so much, Heather. This is incredible. And oh my God, every time I do a video, I always say, gee, I wish I had talked to you before. No, this is really great. Well, thanks so much. And thank you everyone for watching. If you are new to our channel, don't forget to subscribe and hit the bell so that you can be notified of our upcoming videos. And we hope to see you soon. Bye.
Bye.